Welcome to the InfoBrokerWorld podcast, where business intelligence meets global strategy, empowering entrepreneurs with the insights they need to stay ahead.
As an expert in international trademark monitoring and business strategy, one thing is clear: failing to monitor your trademark isn't a neutral decision. It's a strategic liability. When a company registers a trademark, that act is only the beginning. It signals ownership, but without continuous monitoring, that ownership is vulnerable. Vulnerable to misuse, to erosion, to silent takeover. The damage caused by passive inaction can be both severe and irreversible, and often, by the time it's noticed, it's already too late. Let's start with what's at stake: your legal rights. The primary risk of failing to monitor a trademark is the loss of exclusivity. This begins when third parties use your mark, or something deceptively similar, without permission. Over time and without enforcement, the distinctiveness of the mark fades. The public starts to associate your brand name not just with your product, but with an entire category. That's how once strong trademarks like aspirin, escalator, and even Xerox lost their legal edge. It's called genericide, and once a mark is deemed generic, it's virtually unenforceable. In parallel, there's a legal principle every brand owner must understand: the doctrine of laches. If you knowingly allow infringement to continue without taking timely action, courts may consider you to have forfeited your right to object. This is particularly dangerous in jurisdictions with first-to-file systems, where a competitor might claim rights simply by being quicker to act, even if you were using the mark first. Without active surveillance, even a lapsed trademark can be snatched up, forcing the original owner into expensive litigation, or worse, rebranding. And rebranding isn't just about logos or packaging. It's about scrapping years of marketing investment, rebuilding consumer trust from scratch, and repositioning in a market that may no longer be waiting for you. Now let's talk about the financial impact. Legal disputes become exponentially more expensive the longer they're ignored. Once an infringer is established in the market, removing them requires litigation, complete with court fees, legal teams, and long timelines. It drains resources and distracts leadership from strategic priorities. Even small conflicts, if not addressed early, can balloon into costly legal battles, as illustrated by the infamous Nike versus Baby Nike case. What looked like a minor naming issue escalated into years of courtroom wrangling. Another financial trap: missed opposition windows. Most trademark offices, like Germany's DPMA or the EU IPO, don't automatically reject similar trademarks. That job falls to the rights holder, and the clock is ticking. In the EU, for example, you often have just 3 months after publication to file an opposition. Miss that, and your only remaining options are cancellation or litigation, which are both slower and more expensive, but the costs go beyond the courtroom. Failing to monitor means exposing your reputation. If someone else uses your brand or something close to it, your customers may not notice the difference. They may buy the wrong product, they may get poor service, and they may hold you responsible. Every instance of confusion is a lost sale, a missed opportunity, and a strike against your reputation. If the infringing party sells counterfeit or low-quality goods, the damage runs even deeper. Your image, your trust, your entire brand equity is at risk. And then there's brand dilution. Even when there's no direct confusion, widespread unauthorized use chips away at what makes your brand unique. That dilution makes your name feel less exclusive, less valuable. And that perception doesn't just impact customers, it affects partners, suppliers, and investors. Suddenly, your brand isn't seen as premium, it's seen as generic, and that shift can quietly weaken your entire business. For companies looking to grow internationally, the risks multiply. If you're not monitoring new markets, you may run into local conflicts that halt your expansion. Worse, you may discover that your brand has already been registered by someone else. In many countries, trademark squatters act quickly, registering well-known foreign marks before the rightful owners arrive. Fighting these registrations is possible, but costly, uncertain, and time-consuming. And let's not forget about operations. Monitoring the global marketplace manually is no longer realistic. With thousands of new domain extensions, countless social media platforms, and an ever-growing list of online stores and brand registries, the volume is overwhelming. Without automation, monitoring becomes inconsistent, error-prone, and ultimately ineffective. This is where technology becomes essential. Artificial intelligence now powers state-of-the-art monitoring platforms. These systems scan global data sources in real time, from trademark offices and e-commerce platforms to social networks and app stores. They detect visual similarities, phonetic overlaps, and linguistic adaptations. They prioritize risks. They collect evidence. They even generate draft takedown requests and cease and desist letters. And while governments are increasingly adopting AI to combat infringement, brand owners have access to the same level of sophistication if they choose to use it. But AI alone isn't enough. Technology accelerates discovery, but it's human judgment that turns insights into action. Legal professionals must interpret the results, decide what's material, and navigate the complex web of regional laws. They formulate tailored enforcement strategies, file oppositions or cancellations, and guide companies through litigation when needed. Their role is essential not just for accuracy, but for accountability and compliance. Internally, companies must also build awareness. A strong IP culture ensures that team members, from R&D to marketing, recognize the value of the brand and the signs of misuse. It allows organizations to respond quickly, from the inside out. So what's the final verdict? Neglecting trademark monitoring is no longer an oversight, it's a liability. It puts your legal rights, your market position, your reputation, and your long-term growth at risk. In contrast, a robust monitoring program, powered by AI and backed by expert legal insight, transforms trademark protection from a reactive chore into a proactive business advantage. It keeps your brand exclusive, it strengthens consumer trust, and it enables growth, locally and globally. In an economy where your brand is often your most valuable asset, this kind of vigilance isn't optional, it's essential.
Thank you for listening to the Infobroker World podcast. If you have any questions about today's topic, feel free to reach out via the contact details in the show notes. This podcast was created using AI tools. If you're interested in producing your own AI-driven podcast, from concept to audio, feel free to get in touch. We'd love to hear from you. Until next time, stay informed and stay ahead.